Hello and welcome to another class in construction safety. Today we're going to talk about the OSHA Act, and we're going to talk about OSHA in general. How did it start? What is the mandate of OSHA? What does the code say? What are the main components of the code? And how to read the code itself from the published or the printed version. So we're going to talk about the OSHA Act, which is Public Law number 91-596. The Occupational Safety and Health Act of 1970, also known as the William Steiger Act. So what is it and how did it start? The OSHA Act was amended several times by Public Law 101-552 on November 5th, 1990, which increased the OSHA penalties. Public Law 105-198, July 16, 1998. OSHA cannot use citation quotas. Consultation program established, and Public Law 105-241 on September 28, 1998, which placed the United States Postal Office under the Act as well. Prior to OSHA, before establishing the OSHA Act, which is the Occupational Safety and Health Act, which is administered by the also OSHA, Occupational Safety and Health Administration, there used to be state factory laws, which is every employer, every factory used to have its own safety laws to protect its employees. And then there was the federal legislation, Walsh Healey Act, Construction Safety Act, particular to the construction industry, Workmen's Compensation, which is a type of insurance to protect against injuries during work, and voluntary programs by employers. So there was no one common general law that governs safety aspects on projects in general, and especially on construction projects. So some of the reasons for establishing the Occupational Safety and Health Act: failure of existing programs that did not address all the different hazards and the different risks that the employees were subject to. The state programs were limited, so if an employer had to work out of state, for example, they would face different laws. The federal programs were partial, they were not comprehensive, and there was an increasing number of injuries and illnesses resulting from work-related exposure or work-related accidents. For example, 14,000 deaths from job-related accidents, 2.5 million workers disabled because of these accidents, 10 times as many man-days were lost from job-related disabilities as from strikes, labor strikes, and an estimated total of 300,000 occupational diseases, again due to exposure to some hazards on site like silica fumes or asbestos or things like that. So that was one of the OSHA publications, and as you can see it's old, but that number unfortunately kept on increasing. So the purpose of the Act, the Occupational Safety and Health Act, as it's stated on the Act itself in Section 2, is to ensure that every working man and woman in the nation is safe and healthful, to ensure for every working man and woman in the nation safe and healthful working conditions, and to preserve out human resources. That's the major purpose of the Act. Some definitions, as it appeared on the previous section, Section 2, employer and employee. So who's the employer and who's the employee? That appears in Section 3. The employer is the person engaged in a business affecting commerce who has employees. Does not include the United States, the federal government, or any state or political subdivision of a state. So the federal government is exempt from the Occupational Safety and Health Act, and so are the state governments and so on. An employee is of an employer. An employee is an employee of an employer having a business which affects commerce. So anyone working for an employer that qualifies as an employer in the first part of the Section 3 is considered an employee. What is the applicability of the Act or the jurisdiction of the Act? That appears in Section 4. Section 4B1 says that the Occupational Safety and Health Act does not apply to employees where other federal or state agencies exercise authority over occupational safety and health. So if there are other organizations or other regulations that govern the safety and health of these employees, then the OSHA Act does not apply. the duties in Section 5, and the most important part of these of this section is what's called the General Duty Clause, which is Section 5A1. The OSHA Act has the General Duty Clause. Each employer must furnish a place of employment free from recognized hazard. That's the general duty of every employer, and under this clause, so many employers are cited or are penalized because they do not provide an employment place free from recognized hazards. Section 5A2 says that each employer must comply with OSHA standards, and Section 5B says that each employee must comply with OSHA standards and all applicable rules and regulations. So it's a dual responsibility between the employer and the employee. The employer has to provide a place of work that's free from any hazards, and the employee also has to comply with the law and with the directives of the employer to maintain that workplace safe from any hazards or risks. Unnecessary risks, of course, unnecessary risks. The Occupational Safety and Health Standards, Section 6. Section 6A says OSHA has authority to promulgate standards, so they become law. Section 6B, procedures by which OSHA promulgates standards. How is that going to be done? Section 6C, OSHA can provide emergency temporary standards if employees are exposed to grave danger. So if, for example, there's a new kind of hazard that was not recognized before, and we see it on a certain project or a certain construction site, OSHA in this case can provide some emergency measures to prevent this hazard from occurring until a law or until an amendment to the law is added in future revisions or versions of that law. Section 6D, the employers can apply for a variance from a standard. If, for example, they can see that applying the OSHA Act or the regulations according to OSHA is going to result into more hazards to the employers than not applying the laws, then they can ask for a variance from that standard. And we're going to see some examples to that when we address, for example, overhand bricklaying on scaffolds and things like that. We're going to see some of the examples of these variances. The advisory committees and the administration, Section 7. Section 7A establishes the National Advisory Committee on Occupational Safety and Health, which advises the Secretary of Labor. Section 7B, the Secretary can appoint a committee to assist him in his standard-setting functions. Section 7C, the Secretary is authorized to use the personnel of any federal or state agency or consultants to help carry out his responsibilities. So that's very important. For example, the police force can be used by OSHA to enforce some of the aspects of that law. This is not reporting to the Secretary of Labor or Health and Human Services, but again, that's a federal or state agency that can help in implementing the law. Inspections, investigations, and record keeping under Section 8. Section 8A says that OSHA representatives are authorized to, which are called the compliance officers or the inspectors, are authorized to enter without delay at reasonable times during work hours in general, and inspect during regular work hours and at other reasonable times, and to question privately employers and employees. So, what if they are denied entry? What if they try to come to a construction site to investigate a report or a complaint or to check for an accident or something like that, and they are denied entry? They have the right to require to get a warrant, and in this case, preventing them from entering would be a crime. Section 8B says OSHA may require the production of evidence under oath, subpoena power, especially in case of testimony in courts and investigations. Section 8C, employers must keep records relating to the Act. As we're going to see later on what kind of reports and what kind of records need to be filed and need to be kept on site. We're going to learn about these in the future. Section 8F, any employee who believes a violation exists or that imminent danger exists may request an inspection. And as we're going to see later on, at the levels of inspection and the emergency of these inspections, at the top or near the top is going to be something called imminent danger. If there's a complaint from an employee or even someone out of the scope of the construction project, if you are a passerby and you see some conditions that are really dangerous that might result in an accident or an incident, you can contact OSHA and they will respond immediately to prevent such accidents from happening. This comes close to the top of their priorities on inspections. Citations, if there's a violation. Section 9A, if employer has violated Section 5, which is the general duty clause that we talked about, of the Act or any standard, rule, or order related to Section 6 of the Act, citation shall, which means must, be issued. Each citation shall be in writing, so that it's not verbal, it's going to be documented in writing. Describe particular violation with reference to Act, standard, rule, regulation, or order. We're going to see by the end of this lecture how it's referred to in the code, so it's going to mention the clause that the employer did not comply to, and that's why they're going to be cited for that violation, and a time to fix the reasonable abatement period to fix the problem, so that you're going to be given, if someone is cited under this section, they're going to be given a certain period of time to fix that problem, and they're not going to be allowed to work in that area until that issue has been fixed. Section 9B, citations must be posted at or near the place the violation occurred, so that everyone working in that area would know there has been a violation and they would pay attention not to repeat that violation. Section 9C, citations must be issued within 6 months following the violation. If there's an inspection and the compliance officer or the inspector comes and they cite a violation, if you do not receive a written citation within 6 months, then it's gone. They have to give you a written citation within 6 months from the documentation of or the first observance of that violation. The procedure for enforcement is under Section 10. Section 10A says citations go to the employer via certified mail or in person, so that they can claim that it was lost, I didn't receive it. The employer has 15 working days to contest. If you have an objection to that citation, you have to contest it within 15 days. Again, beyond 15 days, there's no right to contest it. Section 10C says any employee may contest the abatement date in the citation. If you feel that the date that was given to fix the problem is too short, you cannot fix it within that time, you can contest that and ask for an extension, but again within the 15 days. The judicial review, Section 11. Section 11A says any person adversely affected by a commission order given under Section 10C may appeal to any United States Court of Appeals. And Section 11C says it prohibits discrimination against employees filing complaints under OSHA, which is the Whistleblower Act. If, for example, I'm an employee, I see something unsafe being done on site, and I report that to OSHA, I need to be protected from being fired or being discriminated against because of whistleblowing. The Review Commission under Section 12. Section 12A establishes the Occupational Safety and Health Review Commission, OSHRC. The OSHRC reviews contested citations and acts independently of OSHA. So OSHA is not the judge and the jury at the same time. If you are contesting a citation, another body is going to review that citation and give another look at it. The procedures to counteract imminent dangers under Section 13. Section 13A allows OSHA to petition the United States District Court to issue restraining orders in case of imminent danger. Again, imminent danger means that something is very close to cause a major accident or incident on site. For example, if you are excavating and the sides of the excavation are not properly sloped or shored, which can cause a cave-in, which can kill employees, this is called imminent danger. It has not caused any accidents yet, but it's very close to causing such accidents. Then in this case, OSHA can petition the United States District Court to issue a restraining order preventing anyone from approaching that site until the problem is fixed. A representation in civil litigation is under Section 14. the Secretary is represented by the Solicitor of Labor. Secretary of Labor in this case is represented by the Solicitor of Labor for any civil litigation brought under the Act. Section 15. What if the OSHA inspector or the compliance officer visits a construction site and the contractor has a proprietary method of construction? They're using a technique that's not known to anyone else, that's the secret of their trade. Now in this case the compliance officer or OSHA inspector has to use confidentiality. They cannot propagate that information to anyone else. So OSHA handles trade secrets as confidential. Procedures for handling trade secrets are in the Field Inspection Reference Manual that is given to every compliance officer or inspector, so they know exactly what are the levels and the limits of that confidentiality. Now, the final thing is penalties. Now, under Section 17, and as we're going to learn later on, there are different levels of penalties under the citations. So we have something called a willful or repeat violation. If you have been cited before, and you are cited again for the same citation, now this is a repeat violation. And OSHA is very strict. For each and every citation or person exposed to that hazard, you can be fined a minimum of $5,000 and a maximum of $70,000. Now imagine a repeat violation or willful, something intentional, willful violation. You have 5 employees exposed to that hazard. You can pay up to 5 times 70,000, so that's $350,000, which is not small change. For a serious violation, a maximum of $7,000, again, per person exposed to that violation. A not serious violation, again, the maximum is $7,000. Failure to correct. You were cited, you were given an abatement period, and you did not contest it, and you failed to correct within that period. Again, there is a citation up to $7,000 per individual exposed. Willful. Now, if death occurs the first time, a maximum of $10,000 plus 6 months prison. So it's not only a financial penalty, there's also prison time. For the second time, of course, I can't imagine a contractor being that negligent, but it happens. It's going to be $20,000 maximum plus 1 year in prison. If you give advance notice, if someone gives advance notice from OSHA gives advance notice about an inspection, then there's a penalty of $1,000 plus 6 months prison. If someone makes a false statement, a maximum of $10,000 plus 6 months prison. And failure to post the violations, if you have been cited, as we mentioned, you have to post the citation for a certain period of time in a place close to where the citation occurred or the violation occurred. Failure to post the violation can result in a penalty of a maximum of $7,000. And all of these, there's the Public Law 101-552 increased these penalties. We're going to talk about these when we talk about in detail about citations and violation. This is a general introduction to the Occupational Safety and Health Act and the administration of that Act. We are going to discuss some other details of that Act as they apply to different parts of construction later on. I'll see you in another lecture.